trial.
This is crazy.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
Sweet Jesus.
You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
It gets worse.
There were drugs involved that were given to me that ended up being glue. Like, I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his meter, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up.
Can you just let this go for once? For once? Once?
Okay, that did
I never want to hear it again.
Are you a whore?
Mr. Sharps,
Not a whore?
Mr. Sharps, Mr. Sharps, Mr. Sharps.
You're not a whore? You're not a whore?
I never want to hear it again.
You're not a whore? You're not a whore?
I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong.
Let's go on the record in the matter of the state of Michigan versus Anthony Kessaloo, 251326.
Right, Your Honor. Good morning, I'm reviewing the lawyer here on behalf of Anthony Kessaloo. Mr. Kessaloo, please state your name.
Anthony Dominic Kessaloo.
Thank you.
All right, thank you. And today is the date scheduled for the.
All right. I have to thank Zach over at Law Nerds Unite. As usual, he pointed out that I didn't play some perfectly good material I had last week, and upon a brief review of the file, I had to put Plaid on.
Sentencing in this matter on your client's plea to an amended charge of operating while intoxicated first offense. The second offense notice, the second offense was dismissed by way of resolution between counsel at the pretrial and counsel as to the report. Is it accurate?
Yes, Your Honor, we've reviewed the report. He wants to give a bit of an update. I'm not sure if actually it's stated here. He is currently employed as a letter from his employer attesting to his work ethic.
I'll take a look at that. Thank you. Okay, what is bagging? What is this? What type of work do you do?
Oh, it's production. We do salt, sand, gravel, dirt.
Okay. And I asked because it's it referenced the arduous nature of your company, of the company.
It's a lot of physical labor there.
Okay,
It's very physically laborious.
okay. All right. And counsel, what else would you like to, is this for the court to keep?
Oh, yes.
Okay, thank you.
Well, in addition to that, a client has been attending a program called Men's Life, which is a support group to help him get a hold of his addiction issue. This is through his church, that's the Metro City Church. The pastor there is acting sort of in a sponsor role for him. And he explains to me that he's getting quite a bit out of that and intends to continue doing that. And so weekly.
Yeah, it's every Saturday, and then I talk with the pastor on Sundays. So there's Men's Life's on Saturday. I talk with Pastor Jonathan on Sundays.
In addition to that, he has written a letter to your honor. He'd like you to.
I'm just curious. Does it count if you go to a gentleman's club? Asking for a friend.
Read it, express his thoughts and his apology to the court, etc. If the court would be so inclined.
I can do so unless you'd like to read it.
If I could read it.
That's fine.
Okay. Your Honor, I want to start by taking full responsibility for my actions. I understand how serious this offense is, and I'm truly sorry for the decision that led me here. I know that driving under the influence could have hurt someone, and I'm thankful it didn't. I take that very seriously, and I've been doing everything I can to show that I've learned from it. Since my arrest, I've stayed completely sober and been fully compliant with my SRAM tether for over 20 days now. I understand that my BAC was very high, and that's something I'm not proud of. I've taken steps to address that by attending a men's group through my church every week, where I also have a pastor who mentors me. These meetings and that support have made a real difference in how I handle stress and decision making. I understand from my assessment that there is a recommendation if the court allows, I'm willing to follow any conditions for counseling, outpatient classes, and or continued monitoring. I believe I can get more long-term benefit from ongoing treatment and accountability through probation than from being incarcerated. I've already served 42 days in custody between my parole violation and county time, and I've learned from that experience. I've used this time to reflect on how I want to move forward. I know this is my second offense, but I'm committed to making sure it's my last. I'm currently working full-time on a production line, and I take pride in being a reliable employee. My employer knows about my situation and has supported me through it. I also take care of my elderly grandfather, and being there for him has helped me stay focused and grounded. I'm asking the court for the opportunity to continue working, caring for my family, and staying active in church and recovery support system while completing any treatment the court requires. I want to keep proving that I can do the right thing every day. Thank you, Your Honor, for taking the time to listen and for considering my situation fairly.
Okay. And so,
you know, he may or may not be sincere. I can't tell from this, but reading it sucks. Like, I don't mean to be too nitpicky, because he might be sincere. I'm not saying he isn't, but it's just so hard to tell anything when somebody's reading from a piece of paper. You get no sense of sincerity, really, one way or the other.
did you write that prior to coming into court today?
I
Write it while you were waiting.
I've been thinking about it, so I've just been trying to figure out how to word it all properly.
Okay. So then you heard me speaking to other people today and thought you should probably make sure you put your thoughts in a concise.
I want to be able to put them in something instead of just coming in here and just, you know.
Okay. So here's
Thanks is always big in.
Here's where there's a bit of a conundrum, because the purpose of probation is to give individuals the tools to rehabilitate and not reoffend. And you have a prior alcohol-related driving offense in June of 19, which shows operating while intoxicated, which perhaps there was another one somewhere along the lines that you were not given the opportunity to have that amended to an impaired. I don't know. Because typically a first offense is reduced to an impaired. So with that not being reduced, that tells me that there was likely something else that was occurring simultaneously or prior to. So possibly this could have been your third offense. I don't know, because I don't have that information somehow. Not only that, sir, you've been in state prison. You realize that you're not allowed to even use alcohol while you're on parole. It's a condition of your parole, sir. So that tells me either you didn't mind your time in custody, or you have a complete disregard for the law. Because you know, sir, that if you're drinking alcohol, that's a violation of your parole. So not only did you drink alcohol, then you got in the car and drove. In a residential area where you were doing 53 to 35, right? Because right where you were at, that's where there's the townhomes, right? Well, yes, at 1:30 in the morning, you would hope that there wouldn't be kids or people running across the street, but you don't know that. And with the level of intoxication that you had at a 0.197, your reaction time, sir, is significantly impacted. And so I can appreciate, sir, that you have taken the steps and you're doing some recovery services for yourself. But I have to be able to find rehabilitative conditions to place you on probation. And I'm not sure if I can find any.
If I could add anything, Your Honor, I mean, it's, it's nothing, but I do have to meet my tether officer every other week for my scram tether. I have to see, I'm currently seeing my parole officer every other week again. She does do drug testing for me. She does do alcohol swabs for me. I know what I did. I should have done it. There's no excuse for it. I had an emotional lapse at the time. It's no excuse, and I understand that. But I just, from the time that I was on parole, I had a year of parole where I didn't have any skills. It did take me a long time to find a job. I got out of prison in August of 24, and it took me almost 9 months to find a job. And my employer, once I did get the job with him, even after the arrest, he did tell me, you do have a job, you've been a hard worker. So that's why he rehired me as soon as I got out for the full one. He rehired me back into work. And I do take this seriously, and I do know that I need the help, and I just feel like more incarceration won't help me. I feel like this stuff that I'm doing right now, the church, the group, outpatient care, any classes, continued work, helping my grandfather out, I feel like that will help me stay grounded and accountable for these actions. I am on the scram tether, obviously. Even after this one comes off, if it did come off or whatever, my parole officer is putting one on me too.
Okay, so let me ask a couple questions based on what you've stated, sir. How often were you meeting with your parole officer prior to this offense date on September 6th?
It was every 2 weeks when I first got out of prison. And then after that, because I had been doing well, it was only a monthly check-in with it.
Okay. And so knowing, sir, that it took you 9 months to obtain employment and that you're on parole, why in the world would you want to jeopardize all of that and consume alcohol?
Yes.
Okay, let's just start with that. Consume alcohol. Why would you want to jeopardize all of that, sir?
It was a mistake on my part.
Well, obviously, because you're here.
I had a girlfriend at the time. Everything was going good with her. I hadn't quite figured out how to broach I've been to prison topic with her. And one of her friends had invited me and her to her wedding and said, "Can I get your boyfriend's information?" She gave her my information. She had looked me up, found that out, sent it to my ex. And, that was the conversation we had. She broke up with me. I'm not saying it's any excuse to go drinking, but it was hard to find somebody who was, as active in my life as she was. And
That's good, because it isn't. Oh, don't worry about it. Don't worry about it. You'll get more ladies with your conviction than you'll lose. Don't worry about it, my man.
She was a great person, and it was just hard to lose that. I know drinking isn't the answer to that, and that was my mistake.
Well, I'm sure I can understand that, because given what your charge was that you were in prison for, I can completely understand, right? Yeah. This is the second person now today that decided they were going to drink and then go get in a car after they had a problem with their girl. Why were you at home when you?
I think it's clear. I think it's clear what the solution is here. We need to outlaw women. It's the only thing that'll work. It's all their fault.
You were drinking, sir?
I was at the bar.
So after the fight, you went out when you went to the bar?
Well, it was about a week after she had broke up with me, and we'd been texting back and forth, and I was, like I said, it was a bad emotional lapse in judgment there. Went to the bar. She had texted me and said, we never had our last night together. And me just thinking to myself of just seeing her one more time, I shouldn't have done it. And, there's no excuse for it, but that's why I got in the car. I was so excited to see her. She's like, come over. And
then take an Uber.
Yes, Your Honor. That's what I've been doing for work. I've been taking an Uber every day to and from work if I can't get a ride from one of my coworkers.
Do you have a valid license right now?
No, Your Honor. They suspended my license. So anytime I can get to my men's life, it's either my uncle driving me there, or if I can take an Uber there.
And so I heard your statement that, incarceration won't help you, right? Well, sometimes incarceration, sir, isn't meant to help somebody. It's meant to put it into perspective, the consequences of your actions, right? And I'm not sure how many chances
There's also the protect society element of this here deal.
one person believes they need to have. All right, I'm going to take a brief recess and then I'll recall this matter. Just a couple moments. All right, let's go off the record.
Everyone, please rise.
All right, and we are recalling the matter of Anthony Kessaloo, 251326.
Dan Neil DeBoy, on behalf of Andy Kessaloo, please state your name.
Anthony Kessaloo.
Okay. All right, and so the court did take a recess because the court wanted to look into a couple more things prior to proceeding with sentencing after hearing Mr. Kessaloo's comments as well as counsel's advocacy.
I don't know. Am I slurring my
and whatnot.
speech?
This is a
If I am, that's scary because I haven't had one drop to drink.
difficult case because Mr. Kessaloo is before this court for an operating while intoxicated, which was reduced from a second offense. Mr. Kessaloo also is on parole for his conviction in March, that conviction being manslaughter, which would then preclude part of some of the conditions that the court could potentially put forth for an individual for an operating while intoxicated second offense matter. And the court has to take into account the safety of the staff as well. And that has to be a consideration this court takes into account. Further, the fact that Mr. Kessaloo is on parole and is still violating parole conditions and consuming alcohol has to be a factor this court takes into consideration. So based upon all that, based upon the level of 0.197, the court does not find that there's reasonable grounds to depart from MCL 769.5. The court's going to order 60 days jail. How long did it take for you to get your tether, sir?
It took, I did the 35 days in Eaton County when they brought me back to Wayne County. It took about a day to get the tether on.
Okay, so I'll give you a day credit for that, and then I'll give you 3 days credit for the time that you're in custody awaiting arraignment in this matter. And so that will be 4 days credit. The court's going to also order a $500 fine, $100 screening assessment fee, $300 supervision oversight fee, $75 crime victim assessment fee, justice system assessment fee of $50 for a total of $1,025. You did post a bond of $1,500. So I don't know if Bethany wants to, it was a third party bond. So I don't know if Bethany wants to apply that bond or not. But if she does not want to apply the bond, then I will indicate that you are to contact the court by end of January to set up a payment plan. All right. You're gonna be going out this door today, sir. Good luck to you.
Thank you.
Let's go on record in the matter of the state of Michigan versus James.
Thank God. I'm just happy they didn't outlaw women. That would be no good for nobody. This guy screwed up for everybody else. That's no fun.
King 251179.
There you are. Your Honor, Neil DeBoy here on behalf of James King. Please state your name, sir.
James King.
All right, good morning. Thank you very much for being very loud. And the court, sir, as to our counsel, as to the arraignment in this matter.
Sorry.
I'm sorry.
This is a sentencing.
No, I'm sorry, sentencing. I'm so very sorry. Change the date time scheduled for sentencing on your client's plea to an amended charge of operating while intoxicated. First offense, driving while license suspended and open intoxicants. And the operating while intoxicated second offense was dismissed by way of resolution between counsel.
Was he yawning through that?
Counsel, do you have an opportunity to review the report and recommendation with your client?
Have one over it. King indicates that there is an update, a negative update. He is full-time employment at Quanta was recently terminated. Is that correct?
It wasn't terminated at Quanta. I had gotten a new job that I was waiting for at Steel Tool Engineering. And when they found out I had a tether, they fired me. And Quanta won't take me back, and I'm having a hard time finding a job. I've applied at multiple places. I'm waiting for Roush and the Oakwood Group to call me back, but no one's calling me back.
Okay.
And a roofing company I also applied for, but that they go out of state, so I don't know how that would work with everything I'm going through right now.
Okay.
So although currently unemployed, it's clear that he's attempting to remedy that as soon as possible. However, I think everything else in the report is accurate, sir?
Yes, sir.
Yes.
Yeah, you know what? Turns out committing crime is detrimental to your job prospects. Who knew?
So the conditions do seem in line with circumstances here. He would prefer, obviously, for the court to consider not assessing the jail at this time. Let him complete his job search, get his feet back under him, and he's committed to sobriety going forward. Anything else you want to add?
My tether officer told me I might be able to get this off at my sentencing. Is that going to happen or no?
Sir, are you for real?
That's fine.
No, just one moment. You're here for sentencing on the second offense OWI, right? Well, actually, it's a first, but it's technically your second. And so instead of utilizing your opportunity to express any remorse or anything like that, you just want to know if you're getting your tether off. That's what I just heard.
That's what my tether officer told me.
You're missing my entire point, sir. You're missing my entire point. It was your opportunity to express your remorse to the court, if you have any. And instead of doing that and acknowledging the poor choice you made on August 8th, your first concern was whether or not you were getting your tether off. That's your concern, not the amount of risk that you put forth to the community or yourself or otherwise. Tell me what's going on with your 3 warrants.
I was working on paying them off and I got fired from my job because of the tether. I was trying to save up money and I got fired, and I had the money I had to spend towards bills.
So that's a, let's see, you failed to appear for a review hearing in the 23rd District Court, October 28th to 24. You've had a year to take care of that, and you have not. You also have a warrant out of the 23rd for double parking that you didn't pay, which is $400. And then also from the same date, a warrant was issued for, because you didn't show up for
Thank you.
paying your stop sign ticket, which occurred in 21, by the way. Let's be very clear on that. That occurred in 21. So you have those matters. And sir, let's just also be very clear that you just had the tether affixed when you were here for arraignment September 18th.
That's the only stupid thing he hasn't done yet is blame a woman for this. You know, I hate it when these women come on there and say every problem in their life is because of a guy. And it's no better when some dopey guy comes on here and starts blaming women. It's your actions, people. That's it.
So you've had a lot of time that you could have taken care of your warrants, and you have chosen not to do so. You also have a prior operating while impaired out of Van Buren in April of 22. And then you also have a fail to report from February of 25 in this court. And sir, how did you get here today?
I got dropped off.
Who dropped you off? How were you getting back and forth to work?
Co-worker who lives Vantage.
And do you have any keys in your pocket right now?
House keys.
No, What else? What is that?
It's a bunch of random keys. There's no car keys though.
Oh, okay. If you're to test right now, sir, what's in your system?
Nothing.
So, sir, not only do you already know what your level is when you're over a .08 and you're not legally able to drive, right? You are more than twice that limit. You're more than twice that limit. And not only that, you're not even legally allowed to drive. And yet you were driving that day. Yet again.
My license had just got suspended at midnight.
But you had noticed it was going to be suspended.
I didn't notice it was the 8th. I think that was the date.
You received notice that your license was going to be suspended, correct?
Yes.
Right. So that's on you, sir, to know what date of the week it is. What day of the month, what day of the week, that's your responsibility.
Yes.
After hearing from counsel, hearing from Mr. King, reviewing the report, the recommendation, the court will find that there is reasonable grounds to depart from MCL 769.5. The court's also going to find the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. King and the legislative guidelines. The court's going to order 18 months probation. You're eligible for early discharge. I'll go over that in just a few moments. You are not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. Do not use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can have assistance in providing coping mechanisms to maintain sobriety and hopefully prevent this matter from happening again. You are to participate in the Armed Weekend Program. The rehabilitative goal for that condition, sir, is so that you can further educate yourself regarding drug and alcohol use and learn trust and coping skills so that hopefully this will assist you in preventing this matter from happening again. As to, then you also have the MAD Victim Impact Panel that you have to attend. The rehabilitative goal for that condition is to help you further educate yourself regarding the dangers of driving while under the influence and the circumstances, the consequences of such behavior. The court's going to also have you participate in fan meetings once per month. The rehabilitative goal for that condition, sir, is to help you in maintaining your sobriety as well as receive some recovery resources. You're not to operate a motor vehicle. The court's going to order 10 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life and work skills and give back to the community. The court's going to order mandatory jail for any probation violation. And the court's also going to order 10 days jail. All that is to count 1 only. Counts 3 and 4 will be fines and costs only. As to, do you have any questions regarding those conditions?
I'm going to jail.
Yes, please keep your hands out of your pockets. For 10 days, you're going to jail, sir.
Please. And I've done no alcohol, no drugs. Please, I'm trying to get a job.
So I understand that.
Please.
But my responsibility is not whether or not you get employment. My responsibility is to make sure the community is safe.
Please.
This is your second offense. And not only is it your second offense, you weren't even legally able to drive that day. And you were at a .178. You have a prior just a few years ago, sir.
Please. I will do anything. Anything.
Sir, that is the order of this court. After your 10 days, you certainly have lots of time that you can obtain employment. Because at that point, your tether will be removed. And you won't have to worry about having a tether be a reason why you don't have employment. As to your fines and costs, the court's going to order a $500 fine as to count 1, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 18 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. Workforce of $400. That's 10 days at $40 a day. totals $2,325. As to count 3, the court's going to order a $300 fine. I'm not assessing a screening or oversight fee. $200 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $625. As to the open alcohol, count 4, $100 fine, $100 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $325. For a total between all 3 matters of $3,275. You did post a bond, so we will apply the bond, and then you'll have to set up your payment plan through probation upon employment. So I can appreciate you haven't used any alcohol since you at least have been arraigned. Okay, so that's good. However, this court has a responsibility. You have prior charges. You have a first offense on the 22nd. You have 3 warrants, and now you have this matter. So that is the order of the court.
Will I be able to call my mom so she can come grab some of my things for me?
You should be able to. I'm not sure they should. You should be able to make a phone call back there. All right, you're going to be going out this door today. Good luck to you, sir.
I was waiting to see if he would cry, which I was disappointed. I didn't get a cry, but I did get, can I call mommy? All right, behave yourselves. It's Saturday night. Take an Uber if you're having fun. I'm not bailing you out.